Hello, I'm Bob Warwick. Welcome to another installment of our show, The Docket. As many of you know, and for those of you who don't, The Docket deals with legal issues and entities that affect you and our community as a whole. We try to present these issues in both an understanding and enjoyable way, and I want to thank you for joining us. And certainly we welcome any feedback or suggestions that you might have. We'll be right back with today's guest. Our guest today is Michael Shane, one of the named partners in the law firm Gordon, Davis, Johnson, and Shane. Prior to private practice, Mark was in the Army, served with JAG, is that right?
No, military intelligence.
Military intelligence?
Yeah.
That's better than JAG. How do you like that? Now, I don't want somebody from JAG coming back at me. He's been an attorney for 27 years, and now, in addition to practicing law, he does mediation. Mike has also been a guest on the program prior to this, and we talked a little bit about mediation, so I thought it would be really good if we came back and we spent the entire time just talking about mediation and letting an expert explain to us exactly what it is and how it's used today in our court system. So Mike, thanks for coming.
I appreciate you inviting me back.
And tell us, first of all, in general, what is mediation?
Okay. In general, mediation is a confidential process where parties in a dispute get together and try to resolve it without being at the courthouse.
All right. So does the mediator act as judge?
The mediator does not. The mediator cannot make any decisions for the parties. And it really is the parties' process. A mediator shouldn't even, you'll say, these are the ground rules. A good mediator goes, what rules do you want to have? Well, we don't know, but let me give you a couple suggestions, and the parties decide how that mediation should go. The mediator's there just as a facilitator to try to get an open and honest discussion about the issues. But a mediator makes no decisions. It's only the parties that can do that.
So are the adverse parties in a room together?
They can be. A lot of mediators like to start with parties in a room together, because a lot of times in a mediation, the parties sometimes need to listen or vent. And you want them to try to be in a room. Now, some attorneys don't like, that's called the general session. If I have my druthers in a mediation, I'd like to do the whole mediation with everybody in the same room. It's a process where everybody knows that it's confidential. I, as a mediator, can never be called to testify about what happened at the mediation unless there's some physical altercation, but a judge can't come in and go, well, Mike, what happened at the mediation? What was their position? I get to go, Judge, by Texas law, it's all confidential.
So let's start with the very basics.
Sure.
Who are the parties to a mediation?
Okay, typically, let's just say there's a lawsuit. Let's say there is a car accident, probably the simplest of the lawsuit. So you would have the plaintiff who sued the defendant saying, you ran into me, and I'm suing you for my damages, property damage, personal injury damages that would have in a case. So you've got the two drivers, and then their attorneys, and the defendant may have their insurance company that's involved as well, because they're paying for that attorney representing the defendant who got sued.
And do the attorneys, and in this case, the representative of the insurance company, do they have any input in the mediation, or are they there to sit and listen?
Well, they are there depending on their relationship with the client. Typically, the attorneys are very involved.
Oh.
They will typically go, here's our legal position, and the other attorney will go, well, here's our position, and here's why we don't like your facts. But you want to have the parties there to go, here's how this is impacting me. Or apologizing. It was my fault or wasn't my fault. And that is all, again, confidential. What any party says in the mediation, the other party can't bring it up at court.
So one party could say, look, I know it was my fault, but, and then it can't be, it's not admissible in court.
Not admissible at court. Again, everything is confidential. The insurance company representative can be involved in the mediations and normally is, because they may be the party paying out the money.
Right.
So they have some input depending on that contractual relationship that driver has with the insurance company.
So you're not in a courtroom, You're
Right.
in a mediator's office.
Correct.
Explain then because it sounds to me, not having much experience in this, although I have been involved in some mediations as an attorney, but what is the benefit? I mean, I think anything basically that can keep you out of the courthouse is a benefit, but what are the real practical benefits to mediation?
The most basic benefit, and probably the most important, is it's the opportunity the parties have to settle it on their own terms.
Without a judge saying this
Without
is
a judge or a jury saying this person's guilty, this person isn't. Say it's a neighbor dispute, fence line or something like that. The parties can come up with a solution that a court could never order. They may, or it's a custody battle. We're going to come up with a custody plan that a court could never order. So the parties are in control. And I always tell them, it's your last opportunity to decide how this is going to be resolved without going to court, without in front of a jury. As you know, as a litigator, going in front of a jury, you never know. You may think you have a great case, and a jury decides you don't.
Sure.
But this way, the parties can be creative. They can do settlement plans. They can do custody plans in their own terms of how they want to do it. They may decide, look, it's a fence problem. We'll move the fence, but you pay 25%, I'll pay 75%. A judge is going to go, you move the fence, and it's all your cost.
Yeah.
So that's the basic thing, is this is their last control, where the parties get to be in control. The other one is they avoid going to court. They can avoid the costs of litigation, which can be very extensive, and they can avoid the risk of litigation. It's a known resolution at the end of the mediation.
Do both parties have to agree to go to mediation, or does the judge say, you will mediate this before you can appear in front of me?
Well, in El Paso County, every civil case goes to mediation.
Oh, is that right?
The Council of Judges, other than I think probate court, have ordered every civil case goes to mediation. If a party doesn't want to go, they have to go before that judge and protest that and go, we don't want to go to mediation. Those are very limited in success, because there's always reasons why. It may be, say it's a divorce case and there are abuse allegations. Well, as a good mediator, we can do that. We never put them in the same room. We protect them from doing that. They never have to see each other. But every case gets assigned to mediation. Now, the parties can agree ahead of time and go, hey, we want to go to mediation, say, even before they file a lawsuit. The parties can say, let's go to mediation. Try to resolve it before we ever even file the lawsuit.
And then who appoints the mediator?
The parties can decide on one.
All right. Oh, does a judge ever say this will be your mediator?
Sometimes, when they're court appointed, typically the judge will allow the parties to select a mediator. If they can't come to an agreement, the judge will appoint a mediator.
And do mediators, like lawyers, specialize in different kinds of law? Do mediators specialize in different kinds of cases?
They can. I mean, every good mediator will tell you, I can mediate any type of case, and we can, and we're trained to do that, because really, as a mediator, you're dealing with people. Now, I do a lot of commercial litigation in my practice. I do a lot of CPS cases, a lot of family law cases, so I'm more comfortable mediating with that because I have a lot of experience with that. My wife, who's a mediator, has been a school psychologist for 27 years. She is excellent at special education mediations, where I could do it, but she's so much better at it.
But she has the expertise.
She's got all that expertise to do that.
Yeah.
And mediators as well, they get in a habit of which ones do they do well. So complicated business litigation, I think I do well. Construction law, I think I do well. Can I do personal injury cases? Absolutely. I don't do a ton of them. There's other mediators that do. That's all they do.
So how do you get the parties start here and here? How do you get them here?
Well, first, before the mediation, you typically like to get a position paper from each side.
That's what the attorney does.
The attorney does that. Say there's attorneys.
Yeah.
Okay, give me your position, and they'll give you, here's our pleadings, here's our legal things, here's why our case is good. A good attorney will say, and here's problems we may have, and that's a confidential statement to the mediator. Both sides do that. So you bring them together, and you let them articulate that if they want to do a group session. Sometimes attorneys are like, no, let's go into separate rooms altogether. And by the way, this can be in person or by Zoom. When the pandemic hit, we started doing mediations by Zoom, which are very useful and very protective, especially with insurance companies.
Sure.
Because their adjuster just has to log on. But you have them talk, and typically you see where they start going. Because they know they're there to try to settle it. They're not going to get everything they want right away if they're mediating in good faith, which the law requires them to do. But you just get them talking and see where they go. If you have to break out into sessions, they're called breakout rooms, you go in and talk, look, I understand your case. Tell me about the problems with your case. And get that client, whose attorney may not tell them all the problems, get them thinking about it and get them talking about the advantages of a mediated settlement. You know, we go down there and I tell them stories about, I've been at the courthouse with the jury, absolutely think I won, jury comes back and I lost.
Right.
And you just, anybody who's tried enough cases knows
that.
That's going to happen. But parties who this may be their one and only lawsuit they ever have just don't understand that. So you really try to get them thinking about their own case, pluses and minuses.
Where does, if you're saying, you really are just a facilitator, where does your knowledge of the law come into effect? Where is that the benefit?
Well, say it's a construction case, and I've done hundreds, thousands of them, to be able to sit there and go, look, I understand your case. What about this? Now, it may be something the other side told you. It may be something I already know. If we're in separate rooms, everything we talk about is confidential as well.
It's confidential to that, yes.
I can't tell the other side if they tell me, hey, we know this is an issue, but don't tell them that. Perfect, I won't tell them that. But between us talking, tell me, because I've had all these cases and I see this issue for you. Attorney, how are you going to address it? And that's important because sometimes the attorney has told their client there are problems, but the client doesn't believe them. So you get this third-party neutral who comes in and goes, no, I really think that's just an issue you have to deal with. So that's kind of where the expertise comes in. If you know that type of case, to go, I've tried hundreds of these cases. I think you have a problem with this.
So it's like, I've tried hundreds of these cases. I think you'll have a problem, and that problem is going to manifest itself if you continue on this line of litigation.
Right. You talk about this is how it could be presented to the jury. Now, the other side may not have brought the problem up.
Right.
It may just be me bringing it up, going, look, I want to make sure I understand your position and how you justify it. So when I go to the other room, and I always tell them, when I'm in the room, you're going to think I'm on their side. But when I'm in that room, they think I'm on your side, because I'm the devil's advocate going, these are problems I see. Let's try to think about how we resolve this.
And so mediation can be less expensive.
Absolutely.
And quicker.
Absolutely. And final.
Final because then you write something up that is the agreement of the parties?
Yeah, we write what's called a mediated settlement agreement. And it outlines the general stuff about a mediation. We came in good faith. If there's a dispute about this document, you'll come back. But here are the 5 terms of the settlement.
If there's a dispute, you'll come back to me or go to court?
You come back to me.
Okay.
Say, we write the mediated settlement agreement. Everybody signs it before they leave. So it's a binding contract. Say it's a auto accident case. One party's going to pay somebody else within a certain amount of times. We're going to dismiss the lawsuit after the payment. Parties sometimes when they leave have a change of heart overnight. And they go, well, I really didn't want to do that. Well, but you already signed this contract. And my mediated settlement agreement says this is irrevocable. Once you sign this, you can't change your mind. People have buyer's remorse all the time.
Sure.
So, but it's a finality that you don't always get with litigation, even if you get a judgment down at litigation. A lot of times parties have said, yes, you have a judgment, but by law they don't have to pay it. You can try to collect on it,
right?
But they don't have to give you a check for $10,000 or $100,000.
Well, that's a good point, though. What happens here? You have a mediated settlement. It says one side is supposed to pay the other side $1,000, and the side that's supposed to pay says, "I'm not paying."
Well, then they've got a breach of contract case,
and so that's another lawsuit.
That's another lawsuit, but it's so much easier to prove up. Going, you signed this, you promised to do that. Very simple case.
Does so a judge does not have to approve the mediated settlement? Nothing?
Does not.
So you get the mediated settlement, you simply, if there is a case filed, file it in that.
The mediated settlement agreements don't get filed in the lawsuit.
Huh.
Because remember, they're confidential.
The actual settlement
The
is
settlement
confidential
agreement
too?
is confidential.
Okay.
Unless there's other parties that don't settle, and then there's a reason under request for disclosure you can find out what the settlement was. But say the parties settled, they just file the paperwork to dismiss the case.
Wow.
The judge never knows. All the judge gets from me at the end of a mediation is the parties came, they mediated, they settled, or they didn't settle.
Well, that's
all
pretty
I tell them.
interesting. I didn't know that.
Yeah, that's all I tell the judge. And that's all they really are entitled to know, because they don't want to know, because it's all confidential, that one party offered this much.
Right.
And this, like a jury can never know. This party offered this
Right.
much. It's all confidential.
Huh.
So the judges never know what the settlement is.
What about attorneys? Have you found the attorneys that you work with being supportive of mediation, or?
I think nowadays attorneys are very supportive of mediation. Mediation is kind of 20, 30 years old, where it's now more norm. Every case, like I said, is going to mediation, and it's more the norm. And I think attorneys appreciate it for their clients for a couple reasons. One, they want to help their clients resolve it as quickly as they can and less expensive as they can. And sometimes, like we talked about, the attorney is trying to tell their client, you don't have $1 million case.
Right.
You've got a $10,000 case maybe, and sometimes the attorney needs that help from the mediator.
Yeah.
And some attorneys will tell us, by the way, my client isn't realistic about where we're at. So that's part of the mediator's job too, is to get that reality sinking in. That you just don't have that.
And it doesn't have, I mean, it's so confidential, I don't know what you can tell me, but I mean, are your cases generally $1 million cases? Are they $10,000 cases?
They range the entire spectrum. I mean, I've mediated cases that are claimed to be worth over $100 million.
Really?
And I've done cases that are $5,000 cases.
So on the $100 million, were you able to mediate it and settle it?
It did not settle at the mediation, but it settled a couple months later.
Oh, is that right?
Yeah. And sometimes they got to come back to a mediation.
Right.
Because they're like, maybe they haven't done enough discovery, and both parties think this witness is going to say this. Okay, well, go depose that witness under oath and figure out what that witness says, and then come back.
And then come back. And how do you charge for mediation? When I say you, I mean in general, not you.
In general, mediators charge by a half day or a full day.
Okay.
So typically in El Paso, for a half day per party, it's somewhere between $500 and $600 per party. So
for a half day?
For a half day.
Okay.
For each party. So if you have two parties, it's for a half day it's $1,000, and it's not an hourly rate. Now some mediators charge an hourly rate. I'll just charge this. It depends. I've done it both ways, depending on what the parties want to do.
And is there any sort of disclosure that's required from the mediator? Let's say you used to be a partner with one of the attorneys, or you play golf with them, or something like that.
I always do. I mean, we do a conflict check like any attorney does with any case.
Right.
Like I can't mediate any case
that's in your office.
That's in my firm.
Sure.
When I have an attorney that leaves our firm, I always disclose that to the other side. Luckily in El Paso, it's a pretty small legal community. Yeah. Everybody kind of knows. But I can't do any case that's at my firm.
Right.
Now I mediate in New Mexico as well. I don't do practice there, I just do mediations there.
Do you have to get two different certifications in for New Mexico and Texas?
No, and you're not licensed as a mediator.
Oh.
There's actually not even certification as a mediator. Texas law just requires you to take the basic 40-hour course. Unless you're dealing with a case involving children, then there's an additional 30-hour course and a 4-hour domestic violence course.
And I'm assuming you have that.
I have all those.
Yeah, because you've already been here with
Right.
the CPS, the Child Protection Services.
Yeah,
stuff,
so there's a Texas Credential Mediation Association. I'm credentialed with them. and you can become parts of lots of organizations that require certain requirements,
Right.
but no license for mediators.
What is, this is a little bit off topic, but what's the difference between mediation and arbitration?
Okay, well, mediation is like we've been talking about. It is non-binding. I'm trying to get you to reach an agreement.
Non-binding until...
until everybody signs everything.
Okay.
Arbitration is that takes the place of court. So the arbitrator is the judge in that case. Evidence is presented to them, and he or she makes that determination. There's no going back and forth. I'm now receiving the evidence like I was the judge as an arbitrator, and I make a written decision. Here's who wins, here's who loses.
Do they, for that, do they get the people together, or is it all done by paperwork?
It's all, most arbitration done in person or by Zoom now, but mostly in person. Each side presents their evidence to an arbitrator, not a judge, not a jury. The arbitrator makes a decision that then gets approved by the, not approved, but entered by the court.
That's the arbitrator.
The arbitrator does that, right.
But, so even though the arbitrator worked as a judge, they still then get an approval of their...
It has to be entered in the court.
Okay.
So now, sometimes that gets paid before they get that whole process done, but yeah, the arbitrator is basically in the position of a judge, can be less expensive to go to arbitration. The rules of evidence, it depends on the judge and what organization is doing the arbitration, but it can also, again, be less costly than pulling in a jury.
Right. So for the mediation, again, let's say, I don't know, child custody. Is that often mediated?
That's mediated a lot.
A lot, okay.
Because, you know, the courts would rather the parents work out a custody case. For example, I work for the 3rd District Court in Las Cruces of New Mexico, and I mediate custody plans for people either getting a divorce or they're just parents that never got married.
Right.
Interesting there, the attorneys are not allowed at that mediation by that court. So it's just the parents, and they work out the custody plan if they can, which includes visitation every week, holidays, you know, a lot of process. And in that one, you're really saying, let's focus on your children. What's best for them? And attorneys are not allowed at that point. Now, if they agree, it's a custody plan that then becomes a court order, that this is your custody plan.
So I guess I'm still a little vague on what happens if, so I know you told me that in the other situation, well, if they don't follow through with the mediated settlement, they've signed it, it's breach of contract.
Right.
What happens in something like the child custody? I mean, is that still considered a breach of contract if the wife doesn't deliver the kid to the husband on Thanksgiving Eve?
Yeah, what happens there really, because like I said, in the child custody, it becomes a court order. So it's not breach of contract. You're in violation of a court order. You could be in contempt of court.
But that's in New Mexico.
And Texas too.
Texas also.
If it becomes a court order, then, and even any other mediated settlement agreement, if they make it a court order, not my document, you know, they produce some other type of order. But in child custody, it would be contempt of court for violating the court order.
Okay, now I don't mean to be dense here, but I'm trying to follow this. I thought that the mediation, you did not give it to the judge. He had nothing to do with it, so there was no court order.
Well, we're talking about the custody cases in New Mexico.
And here also.
And here also, it can become a court order.
Okay.
Depending what the judge wants. Now, typically here, they make a separate order, and it's not the mediated settlement agreement.
Oh, it's just based on the mediated settlement. I got it.
Right.
Okay.
Now, in New Mexico, that particular issue, I submit a custody plan, which the parties have to sign, notarize. I sign it, and then the judge signs it and makes it an order.
Okay.
It's just the process they use.
And what happens if both parties say, we don't want to mediate? You know, the judge, like you say, the judge, everybody has to go mediate a civil case.
Right.
But if they say, we don't want to, period.
Well, they're court ordered to come mediate, and they're court ordered to come mediate in good faith. Now, sometimes the parties go, we just can't agree.
Yeah.
So we use all the tricks in our bag, and we've got them separated. We put them together, we got them separated, and they just can't reach an agreement, then they just can't reach an agreement. Yeah,
Yeah.
they don't have to. I can't make them agree to anything.
Right.
I mean, I've had mediations fall apart over the dumbest thing, but it fell apart over a dumb thing. Like one example, without disclosing a lot, it was a piece of furniture. They both wanted it. I had everything else settled, but this piece of furniture.
Wow.
And didn't settle over that. So I report to the court. They came to mediation, mediated in good faith, didn't settle it. Judge,
And now they're
take it
going to go back to court and spend a fortune on a couch.
They did.
I would have ordered the couch be sold, and neither of them,
Well,
neither of them get it.
I'm not the judge, and
Right.
as a mediator, I can't order that. But it was
interesting. I mean,
Yeah.
I'm, lawyers will probably hate me for saying this, but I'm for anything that basically keeps you out of the courthouse.
sure, because you never know what's going to happen.
But it also makes a lot of sense for the people because they don't really realize, I don't think, what it involves once you get down there. And it takes on a life of its own, and you lose control, where in something like mediation, you maintain a modicum of control.
And I always tell them that. I go, like we talked about, what's the advantage? This is your chance to keep control.
Yeah.
I go, if you go down to a trial, and you've all seen it on TV, you don't know what a judge or jury is going to do. And you take that risk going down.
And you don't know what you're letting yourself in for.
They don't know. And the cost. I always say, when we're having struggling, I go, okay, Mr. Attorney or Miss Attorney, how much are you going to charge this client to go to trial? How much more is it going to cost? And when they give them that number, some people look and go, okay. When it's not a contingency fee case.
Yeah.
But yeah, you tell them that and go, okay, what if the jury doesn't agree with you? You could wind up with nothing and owing the other side something.
And that, I think, is a problem. People get so stuck in, I guess, their righteousness.
Right.
I am right, and I am going to recover, and this is nuts. But
yeah, they're in their lane, and they go, but it was morally wrong what they did.
yeah.
Maybe, but was it legally wrong?
And how much are you willing to pay for
Right.
morally wrong? Or, it's like,
Sure. And some people just are never going to settle.
right.
And you sit there for 4 hours with them, and you can only do so much, and then you just go, okay,
And this
I'm
is
done for
all
the day.
civil, correct?
Yeah, no criminal.
No criminal at all.
I mean, there's negotiations in criminal cases. But not with a mediator. I
Right.
think that's just the prosecutor
Yeah.
and defense attorneys
Yeah.
do that.
Man, we're out of time. I mean, I can't believe how this stuff goes so quickly. I really think that's fascinating. I also think it's probably the way for law to go. I mean, it's become quite expensive, and a lot of people can't afford it. And this may be the way to settle disputes. That the only thing is you have to get both parties to do it. And the only way a judge can force you to go to mediation is one party filing the lawsuit in the first place.
Correct.
Yeah, so listen, I appreciate it. I know you're a man of many talents. I'm sure you'll be back here on something else to talk
pleasure.
about. Thank you so much for coming.